in order to cover the current situation, because I would say there are some gaps in the legal system as of today that are able to address the current situation. However, this webinar is just to address the situation as it stands from Kuwait law perspective. What are the issues that we are going to consider today? 3 major items we are going to discuss. Number 1, force majeure and emergency situation cases. Number 2, Kuwait labor law related matters. And number 3, commercial and residential lease agreements. Everybody right now is asking questions, whether they should be paid or not. Can they be evacuated if they don't pay their lease or not? What about their agreements, their commercial agreements when it comes to businesses? What's the status on this one? Is the situation going on right now with the curfew? Is it regarded as a force majeure event, or is it regarded as an emergency situation? And in both cases, what are the implications, whether it is regarded as force majeure or emergency situation? As Paula said, I'm sure you have a lot of questions, and we will be taking them one by one. I will be basically taking those questions at the very end of the presentation. You can write your questions in the chat icon, and I'll take them one by one. So let's begin. Why am I not able? Just a second. Okay. So, as I mentioned, the 3 things is, number 1 is the force majeure and emergency situation. This is basically related to businesses and to companies more than it is related to individuals. There are a lot of contracts right now, whether government contracts, whether supply contracts, any kind of contracts you can talk about. Some of those contracts have been suspended during this period. Some others have resorted to termination, and some others are still thinking of what they are going to do with their current contracts. The first question, or the first thing that you should do, is get the agreement, whatever agreement is your concern. You need to check the provisions of that agreement, and to check whether in that agreement you have a force majeure clause or you don't have a force majeure clause. So as one of the principles of law, as it says in Arabic, al-aqd shari'at al-muta'aqidin, what that means. This means the parties to a contract can agree to whatever they want in a contract, as long as that contract does not violate public policy, it does not violate ethics, and it does not violate orderly provisions of the law. So if the parties have already a force majeure clause in their contracts, they should first go back to that and see what it says. Because usually in any contract, a force majeure clause is defined. So they define exactly what a force majeure event is. They defined it in the agreement. They also list what are the situations that form a force majeure event in that contract. And number 3, they also determine what are the procedures and the implications of the force majeure. So if you have a contract and you have a force majeure provision, that's where you need to start at the beginning. However, if you do not have this kind of provision in your contract, then we should resort to the general laws and regulations of Kuwait, being in principle the civil code, which governs both force majeure events and emergency situations, and there's a difference between those two. And there are court precedents as well, which have been issued during the past period regarding the definition of both force majeure and regarding the definition of emergency situation. Most of those precedents were issued during the Iraqi invasion. So in Kuwait, I would say that the period which mostly is similar to what we are going through right now was during the Iraqi invasion, where businesses were stopped, labor contracts also ceased to take their effect, where there were issues with lease agreements. So the only situation which happened in Kuwait, and there were precedents available similar to our situation, was during the Iraqi invasion. So let me start right now by determining what is an emergency situation according to the law and what is a force majeure event according to the law. Article 198 of the Kuwait Civil Law has determined what an emergency situation is. And as you can see, it says, should any public exceptional circumstances occur after concluding the contract and before completion of implementation thereof, which were unexpected upon concluding the contract, and the occurrence thereof ensures that the implementation of the obligation resulting therefrom becomes tough but not impossible, yet becomes more burdensome to the debtor, such that it threatens him by a great loss. The judge, after comparison between the interests of the two parties, may return the burdensome obligation to the reasonable limit by decreasing its range or increasing the consideration thereof. And any agreement to the contrary between the parties shall be invalid. What does that mean? This means that there are conditions for a judge of law to determine a case or a situation to be regarded as an emergency situation. And as you can see from this page, the ones in red, those are the conditions for an emergency situation. Number one, it should be an exceptional circumstance. Something does not occur every day and something which is unprecedented. So does the COVID-19 and the curfew which we are going through right now is regarded as exceptional circumstance? Yes, it does. Number two, it should be a public situation that applies for the whole community. So it is not only, for example, to a specific industry or to a specific field or to a specific individual. It has to be public. So it applies to the whole community. Again, this is again one of the conditions that applies to what we are going through right now. It has to be unexpected and unpredictable at the time of signing the agreement. Again, whenever we signed agreements before the 15th of March, anybody who signed agreements, regardless of what that agreement is, nobody expected that in March and April, we would be sitting home, not able to practice our normal life. The fourth condition is that the situation is unavoidable and unpreventable. So we cannot control it. We are trying as much as possible, basically, certain contracts can be implemented or can be executed virtually. However, other contracts cannot at all be executed virtually. So again, the situation we are going through is also unavoidable. The situation to be regarded as an emergency situation as well, it has to be after the signature of the agreement and before completion of implementation. So if a contract has been concluded before the 15th of March, then the emergency situation and the force majeure and all those situations we are talking about will not be applicable to it, as the contract has started and finished before the current situation has occurred. Finally, the obligation becomes very tough and burdensome, causing loss damage. So basically, what does that mean? This is key. This is key because this is the major difference between an emergency situation and a force majeure event. In an emergency situation, the obligations in a contract become tough and burdensome to both parties. Let's take, for example, an employment agreement. The employer, it will be burdensome for the employer to pay the salaries of the employees on time or to pay them fully. And at the same time, it becomes burdensome to the employee to perform their obligations under the contract, which is performing their work, especially for those employees whose work makes them or forces them to be physically in the work premises, so they cannot do their work virtually. However, in an emergency situation, the obligations do not become impossible to do. And one of the things as well that you need to take into consideration, that the situation altogether, for it to be regarded as an emergency situation, it has to cause gross damage to any of the parties involved. So this is generally the emergency situation conditions. If we look at them in a whole and we look at the conditions, we see that each and every condition of those emergency situation conditions applies to where we stand right now, unfortunately. We move to the force majeure now. The force majeure is not defined under Kuwait law per se. So there is no definition of force majeure under Kuwait law, whether the civil code or the commercial code. It is mentioned in the laws, mentioned in the civil law in several articles, which I'm going to discuss right now, and mentioned as well in the commercial law, also in several articles, we are going to go through quickly. But as a definition, it has not been defined in Kuwait law. As I mentioned at the beginning, usually agreements do define their own provisions of what is force majeure. They define what force majeure is, they define its implications, and they define the procedures. If an agreement is silent, then we resort to the general laws and regulations. Since we do not have a definition of the force majeure under Kuwait law, we resort to precedents in this regard. One of the articles which is very important and mentions actually the implications of a force majeure event is Article 215 of the Civil Law, which basically says, in contracts binding on both parties, if the implementation of the obligation of one party becomes impossible. So let's compare this word to the emergency situation. In the emergency situation, it becomes burdensome and tough. In the force majeure, it becomes impossible to perform. For a foreign reason not attributable to the party, such obligations shall expire, and the corresponding obligations on the other party shall expire too, and the contract is terminated on its own. So those are the implications of a force majeure event. If the impossibility is partial, the creditor may, as the case may be, hold on to the parts of the contract that can be implemented or request termination of the contract. So what do we conclude from Article 215? We conclude, number one, that one of the conditions for a force majeure event is that it leads to the impossibility of performing the obligations of both parties to the contract. What are the implications, however? The implications basically will be the release of liability of both parties and termination of the contract. So no party in this situation will be responsible to the other party for any obligations in that contract. As I mentioned, the only situations that Kuwait has gone through, which were similar to what we are going through right now, were during the Iraqi invasion and the Gulf War. At the time, there were a lot of precedents issued, and some of those precedents also related to government contracts. So the emergency conditions, the emergency situation conditions, and the force majeure events, both of them apply to government contracts, and they are viewed almost the same. And in this fatwa, which was issued in 1991 after the Iraqi invasion, they basically compared between two situations. It compared between partial impossibility and complete or full impossibility. Partial impossibility would be regarded an emergency situation, and complete impossibility will be regarded as a force majeure event where parties cannot perform their obligations under the contract anymore. And if the impossibility was complete, in this case, the obligation of the debtor will terminate accordingly. So there will be no obligations on either party, as we said. However, if the impossibility is partial, in this case, the contract will stay valid between its parties. However, it will be suspended during the emergency situation crisis. So during this situation, it will be suspended, but the contract remains valid. Another important article which also addresses force majeure in one way or another is Article 437 of the Civil Law. Article 437 has established another condition for a force majeure, which is basically that the situation is unpredictable and unpreventable. Not only unpredictable, but also unpreventable. And those two conditions come together. So if the situation was unpredictable, but could be prevented, it will not be regarded as a force majeure. For it to be regarded as a force majeure, both conditions have to be available. Unpredictable, so you could not foresee that this event will happen in the future, and unpreventable, you were not able to do anything in order to mitigate the risk of not performing the obligations under that contract. So what is the difference between force majeure and emergency situation? A force majeure event leads to the impossibility of implementation of the agreement and fulfillment of the obligations, while the emergency situation keeps the contract as it is. However, the implementation of the obligation becomes tough and burdensome, but not impossible. In a force majeure event, it leads to termination of the agreement. In an emergency situation, it does not lead to termination of the agreement unless one of the parties requests for termination. The agreement remains valid. However, it will be suspended during the situation, and the obligations of the parties will be adjusted in order to take into the consideration the interest of both parties. In a force majeure event, the commitment and the obligation of both parties comes to an end, and there is a complete release from liability. However, in an emergency situation, the obligations and the rights in an agreement remains valid, but are adjusted to the interest of both parties. Now the question that comes to a lot of people: if I have a contract, whether it's a commercial contract or a personal contract or an employment contract or any other contract to that extent, how do I classify this situation for my contract? As I said, the first thing that you have to do is check whether your contract has a force majeure provision. So if it has a force majeure provision, then you have to follow that provision. If it does not have a force majeure provision, then we resort to what we have discussed right now regarding the force majeure and emergency situation. In my personal opinion, what is happening right now is an emergency situation, and it will be regarded as such as of today, because the biggest problem that we are facing today is that we don't have a deadline. We don't know whether this situation is going to continue for another month or 2 or a year. We have no idea how long this situation is going to continue for. As of today, the situation will be regarded as an emergency situation for most of the contracts, I would say. However, some of the contracts, force majeure will apply to them, and it depends on case-by-case basis. So what I'm saying does not apply to each and every contract out there. I'm going to talk, of course, about labor law contracts in specific and lease agreements. However, all other contracts, whether government contracts or commercial agreements or supply agreements or agency agreements or anything like that, they have to be taken case by case basis. They have to be reviewed according to their provisions. And then we need to take into consideration as well the implications of the civil code in Kuwait and the conditions of the emergency situation to that contract. So this is something that you have to take into consideration. Now, one of the things that I have to mention before I go into the labor law matters, which I know that most of the people are concerned about, is that the emergency situation or Iraqi invasion to Kuwait at that time mostly was regarded as an emergency situation and not as a force majeure regarding a lot of contracts. Because as I mentioned before, the obligations of both parties were suspended. So during the Iraqi invasion, what happened at that time, or what most of the courts have judged during that period, is that during the Iraqi invasion, there was suspension of the obligations of both parties in a contract. However, the contract remains valid. So after the Iraqi invasion was over and the Gulf War was over, the contract was resumed according to its conditions and was continued accordingly. The situation, however, during that time is different from this time because of various reasons. Let me start, number one, by saying regarding the labor law, right now we have the internet, we have the new means of communication. So people can communicate with each other, can meet virtually, can send emails. So there's a huge difference from the manner of doing business in 1990 and 1991. And the other thing, the Kuwait Labor Law has been amended in 2010 and has included new articles which were not available at the time, which are, I would say, more beneficial to the employee, but at the same time are burdensome to the employer, which we are going to go into details regarding those issues. The first question which everybody is asking about, should I get paid according to my contract? I have a contract in place, an employment contract. Should I be paid or not? One of the articles in the new law, I still call it a new law because, I mean, it is in 2010, but we still call it the new labor law, is Article 61. And Article 61 is very, very clear. It says that the employer shall also pay the remuneration to the employees throughout the complete or partial period of closure in case such closure is due to any other reason not related to the employees, as long as the employer wishes that the employee keep working for the employer's account. What does that mean? That means as long as your employer wants you to continue performing your obligations under your employment contract, or I wouldn't say performing your obligations, because as I said, some of the employees out there are able to perform their obligations under their employment contracts virtually, some others they can't. So here, the employer has the right to keep the agreement in place and not to terminate the agreement. If the employer decides to keep the agreement in place, that means the agreement is still valid, and that means the agreement will still have all its obligations intact, meaning that the employer has to pay the employees their salaries. The second question as well that everyone is asking, can the employer terminate the employment agreements? In principle, yes. So the employer during the situation can simply say, I want to terminate the employment agreement according to my rights in the labor law. However, in the event of termination, the employer will have to pay the employee their entitlements, because this is termination, not resignation. In the event of termination, whether the contract is definite term contract or indefinite term contract, and there is termination, the employee is entitled for full end of service indemnity. If the contract is an indefinite term contract, in this case also the employer has to pay 3 months notice period. So yes, in principle, the employer has the right to terminate the employment agreement on the condition that the employer pays all the employees' entitlements and the notice period and full end of service indemnity. Now, some people are saying that employers cannot terminate employees during this period according to Article 45 of the law. Article 45 basically says that you cannot terminate the employment agreement of an employee as long as the employee is enjoying or is on vacation according to one of the leaves as stipulated in the law. There is one party that is saying that you are unable to terminate the employment agreements according to that article. However, you need to take into consideration that the law in Article 68 has defined the public vacations and has defined the public holidays per se, which are 13 days in specific. The law has determined them. If we go back to Article 45, Article 45 regarding termination stipulates that you cannot terminate the employment agreement of an employee enjoying one of the vacations determined under the law, which is in Article 68. However, the vacation, or I wouldn't say vacation, the time we are off work right now is not something determined in the law or in Article 68 of the law. It is not determined in there. So my personal opinion, or our personal opinion as a law firm, is that as of today, the employer, according to the law, has the right to terminate the employment agreement of an employee on the condition that they give the employee full end of service indemnity, 3 months notice period in the event that the contract is an indefinite term contract, and any other entitlements the employee has. The second thing also that is going on right now is that some of the companies are trying to force the employees to sign resignations instead of termination letters. Of course, this is something that everybody had to be aware of. Termination is one thing, resignation is something else. Termination means that the employer, termination from the side of the employer, means that the employer has to pay full end of service indemnity. Resignation of the employee, however, on the other side, means that the employee will not get full end of service indemnity. If the contract is an indefinite term contract, the employee in this situation will get end of service indemnity according to the number of years the employee has spent in work. So if the employee has spent in work 1 to 3 years, he will not get end of service indemnity in an indefinite term contract if he resigns. If the number of years of service are between 3 and 5 years, the employee will get 50% of their end of service indemnity. If the number of years spent at work is between 5 years and 10 years, the employee will get 66% of their end of service indemnity. And after 10 years, they will get full end of service indemnity. So you can see there's a huge difference between termination and resignation. So this is something that everybody has to be aware of. Termination, you get full end of service indemnity. Resignation, you don't. Indefinite term contracts as well, it's a bit different, but still you don't get your full end of service indemnity if you resign. they're treated differently. One of the questions also that we are getting is, can the employer force the employee to sign an unpaid or paid leave for the shutdown period? So let's say that one of the employees have accumulated leave that they haven't used yet. Some of the employers are using those accumulated leave and deducting them from the employee's annual leave in order to cover the situation. However, when the Kuwait government decided to go and have a curfew, what did they do? They said that from the mid-March until the end of March, it is regarded as an official vacation. And from the end of March until almost 29th of April, it will be regarded as a rest day, Yawm Raha, which means that the Kuwait government has already in its resolution determined what the situation is. So you cannot basically come as an employer and employee and determine that this period is unpaid leave or paid leave, while the government has already determined and announced that this period is half of it so far has been declared as official vacation and the other half so far is regarded as rests. What's the difference, by the way, between official vacation and rests? Official vacation, if an employee works on an official vacation day, according to the law, they get paid double their salary plus 1 day off extra. However, if an employee works on a rest day, they get paid 1.5 their salary plus 1 day off. However, I don't think this will be applicable, and I think that the Kuwait government will issue laws and regulations to that extent in the future for anybody who is working during this period. But this is the difference between official vacation and rest days. Lots of employers also, what they are doing at this stage is cutting salaries in half and waiting to see what the situation will be. Legally speaking, and as of today, what the law stipulates, you have no right as an employer to reduce the salary of the employees, according to Article 62 of the law, which basically says that the employee's remuneration cannot be reduced for any reason during the period of service, for any reason. This article, although it is somehow, I would say, fair for the benefit of the employee. However, in those situations, lots of employees are basically saying, I prefer not to take my full end of service indemnity and not to take my entitlements. What I prefer at this stage is to continue working, even though I get half salary paid. So what's the solution? The law does not allow the employer to reduce the salary. The employee agrees to reduce their salary during this period because for the employee, he just wants continuity of work. Lots of employees at this stage just want continuity of work. So far, there is no legal provision that allows for reduction of salary. If you take, for example, in the UAE, in Dubai, the government of Dubai has issued basically an amendment to the labor law during this period, last week, to be in specific, in which the UAE have said or allowed the employees and the employers to agree to reduce salaries. And I think that the Kuwait government should consider this as an option because, as I said, a lot of employees at this stage just want to make sure that they have a continuous employment agreement in place, regardless of whether the salary is reduced by half or less or more than that. But as long as the employer and the employee agree to that reduction, there should be some provision in the law that would allow that. Now, what happens in the event the employer forces the employee to sign documents to settle to any arrangement against the employee's interests? Some of the people are calling us and asking, or basically sending us documents telling us that our employer has asked us to sign this document. Should we sign it or not? That document can be a resignation. That document can be signature that they have agreed that the time off is paid or unpaid leave, that the amount will be deducted from their paid or unpaid leave regardless. What would happen, sometimes the employee is forced to sign those documents, especially that the conditions right now are extraordinary. Everybody is stressed, everybody doesn't know what they need to do. In this case, if you sign those documents, you still have the right to challenge those documents within 3 months period after signature of those documents, according to Article 115 of the law. The issue, however, right now is that the courts are not opened and you cannot go and file a complaint, because in employment matters, the employee cannot go directly to the court and file a case. Before going to the court, as a condition precedent, if an employee wants to file a case against the employer, they have to first go and file a complaint in front of the Ministry of Social Affairs and Labor. And right now, all the public entities are closed. However, there was an amendment in the law, which we are going to discuss later on, which take into consideration the timelines to file cases. And there is already an amendment to that extent. Finally, when we come to labor law issues, one of the questions that is coming to us from US clients in specific is whether employees have the right in Kuwait to raise what is called class action lawsuits. What is a class action lawsuit? A class action lawsuit is basically the right of a number of people who have a common issue to raise one case against another party regarding the same subject, where everybody would be included in that case. So instead of each employee going and raising a case against, let's say, let's talk, for example, of a company that has a lot of employees and they have been terminated. Let's say 100 employees, and those 100 employees were terminated. So instead of each employee going and filing the case by himself against the employer, all those 100 employees can do what is called a class action lawsuit, in which one case is raised against that company or that employer to request for the same rights. Unfortunately, we do not have that system in Kuwait. We don't have class action lawsuits in Kuwait. The law does not allow us so far. So this is something else to consider, because after the situation is over, we are expecting that there will be a lot of cases from employee and employer perspective. One thing that I need to mention before we close on the labor law, there's no magic solution right now for anything which is happening. The law is the law. However, in practice, what you do is something different, and each company is dealing with the situation with what they have. Because at the end of the day, the employers and the companies are in a very tough situation. They're not able to work and they are not able to get any money into the company, and therefore they're unable to pay the employees. And at the same time, the employee, which is regarded here as the party which is protected under the law, also they are in a tough situation because they are not getting paid. And if they don't get paid, there are obligations on their side. And right now, everybody is in survival mode, which is basically everybody wants to make sure that they pay their rents, and everybody wants to make sure that they have food on their plates for themselves and for their families. So everybody right now is on survival mode. I can understand both positions, to be frank. I can understand the employer's perspective. They are in a very tough situation, and the employee's perspective as well, who are also in a very, very tough situation. The only way to get out or to try to resolve this crisis is to work, and this is one of the things I think ABCK is doing, is trying to work with the Kuwaiti government to see what we can do in order to make sure that everybody, as much as possible, do not get or get least as much as possible damage during the situations, because as I said, those are unprecedented times and unprecedented situation. I'm getting questions. I will be answering them later. I'm not going to go through them right now. And some of those questions are related basically to some specifics regarding some contracts. So I have some questions related to specifics. Any questions which are related to specifics, I'm going to try to answer them in a general manner. Anybody who has a specific question, you will have my contact details later at the end of the slide, and you can contact me accordingly for any questions or specific questions that you might have regarding your own situation. Okay. During the Iraqi invasion, there were court precedents in regard to labor law matters, and they considered that the emergency situation applies on labor or employment agreements at that time. And they considered that during the wartime, the contracts or the employment contracts were still valid. However, they were suspended during that period, and after the war ended, those contracts were back into force and effect. And during that period, during the Iraqi invasion, the employees were not paid because they were not doing any work, and at the same time, the employers did not pay. However, there's a difference between then and now, as I mentioned before, which is Article 61 of the law, which is an orderly provision of the law, which obliges the employers to pay the employees their salaries during the period of shutdown, as long as that shutdown is not or does not relate to an action done by the employee himself. So there were precedents at the time in which they regarded labor contracts as emergency situations and treated them as such. We go now to the lease agreements. In the lease agreements, there are two types of lease agreements. There are residential lease agreements, and there are commercial and investment lease agreements. What is the difference between those two? The residential lease agreements are subject to the lease law, which is decree number 35 of 1978. However, the commercial/investment lease agreements are subject to the civil law. And the difference between them is that the investment lease agreement differs from the normal lease agreement is that it has extraordinary provisions. And the courts have regarded that an extraordinary provision, for example, would be if the lease agreement contains, for example, a provision regarding insurance, fire-related insurance, or insurance on the employees, or any kind of insurance. So if there is insurance in the contract, the courts have regarded this as an extraordinary provision, and therefore regarded the contract would be classified as an investment agreement. So what's the difference right now regarding the situation that we are in? Regarding the residential lease agreements, again, everybody is asking, can the landlord evacuate us? we're coming into that in a second. Let me first finish this slide. So let's start with the first one. Can the landlord and the tenant reduce the lease payment in the residential real estate during the shutdown? Yes, they can. And this is the best case scenario. The best case scenario in residential real estate is that both the landlord and the tenant agree to reduce the fee, the lease amount during this period. And also, if the government issues any laws or decrees to that extent. Article 11 of Law number 35 of 1987 basically says that the agreed upon fee in the lease agreement is obligatory to both parties and cannot be amended except by their agreement or due to reasons determined by the law. So according to Article 11, they can agree, the landlord and the tenant, to reduce the lease amount during this period. We come to the commercial and investment leases. Which is subject to the Civil Code, in particular Article 581. Article 581 specifically states that if an act is issued by a public authority within the limits of the law and results in a significant lack of access of usage to the tenant may request that the contract be terminated or the lease value be reduced unless the authority's decision is a result attributed to the tenant. So basically, what it says that, or the key to this article, is that the company which is leasing that property is getting use of the premises. And right now, during the lockdown, most of the companies are not working. Most of the companies are not going to the premises and doing their work from home if they can. So they are not getting the benefit out of that lease agreement. They're not using that premises as they are supposed to do according to the contract. Also, there are court precedents which were issued at the time of the Iraqi invasion in specific to commercial and investment lease, in which the courts at that time stated that in the event a company does not pay for the rent during an emergency situation, crisis, they have the right to do so since they did not get use of the premises. So their interest out of that contract was not attained. And therefore, since their interest of that period or that contract was not attained, they have the right not to pay. This was one of the precedents that was issued during the Iraqi invasion. A lot of companies right now, they have already basically informed the landlords or the owners of the building that they are not going to pay. Hopefully, and taking into consideration the precedents that were issued at the time, and taking into consideration that the courts will somehow stand on their side, as this will be regarded as an emergency situation, and it will suspend the obligations of both parties in a commercial investment lease agreement. Now, a lot of people as well, there are some owners who have been kind enough to come and tell the tenants that they are allowed not to pay the rent for March and April. However, there are some owners on the other side who have come and said no, and they have sent notifications to that extent to the tenants, telling them that you have to pay the rent amount according to the contract by the end of the month, or else please evacuate the premises. If we want to speak legally, a landlord cannot immediately evacuate the tenant. several things have to be taken into consideration. First of all, you have to review your lease agreement. In your lease agreement, do you have a period specified in that lease agreement stating that you have a certain period to notify the tenant or to notify the landlord, whichever wants to terminate the agreement, to evacuate? If you do have that notification provision, then you need to take that into consideration. So before the landlord comes and tells the tenant to evacuate, he must take into consideration the timeline for evacuation or notification to evacuate. If there's one in the agreement, then you have to go with the timeline or notification period specified in the agreement. If there is none, Article 19 of the law has determined those time periods. In lease agreements, where the period of the lease does not exceed 3 months, the notification is 15 days. In lease agreements where the period of lease exceeds 6 months, the notification has to be at least 1 month. And in lease agreements where the period exceeds 6 months, the notification period has to be 2 months. So if you don't have an agreement or a provision in your lease agreement that determines the timeline, the law has determined it in Article 19. So before any evacuation, a notification has to go out from the landlord to the tenant, requesting them to evacuate within the timeline stipulated by law. Let's say that it's 1 month and the tenant has been already notified to evacuate the premises. So they have that 1 month. Even in this case, the landlord, according to the law, cannot come simply and tell them to get out of the house where they are in simply because they did not pay. In this case, the landlord has to raise a case, which is a case for eviction, in front of the lease circuits in Kuwait. And right now, all courts, as you are aware, are closed. So right now, the landlord does not have the option to go and file a case against the tenant to evict them from the premises they are living in. And even when a judge issues his decision and then an execution file is opened, it will take also some time for the procedures in order to evict the tenants. On the other side, the law also gave the landlord the right to raise what is called a payment order request, in Arabic, Amr Ada. Amr al-Ada, or the payment order request, is an order in which it is raised, first of all, in front of urgency courts. And in this case, they have the right to raise Amr al-Ada in order to request for payment of any due lease amount, not for eviction. So the payment order request is only for payment or any due lease amount. There are conditions for Amr al-Ada. So Amr al-Ada, it is not also as simple as that. There are conditions for it. And there are some documents that have to be provided, which I have listed herein. So there's also a procedure for this. And the court, the urgency court right now is also closed. So all the court system right now is suspended because of the situation. Another question which is coming from a lot of people is that some of the landlords, what they are doing is that they are cutting electricity and water from buildings in order to force the tenants to leave. Can they do that or can't they do that? They can't. And I'm sure that in the past week you have heard similar situations in the news. You have read about them. What would happen in this case is that if this happens in your building, simply contact the police station in the area where you are living, and they would come and return the electricity and water to the building. So this does not need a court order. This does not need any procedures. All you need to do is just call the police station in the area where you are living, and they will make sure to resume those services in the building that you are living in. What does this mean? Does this mean that you should not pay your lease amounts during this period? Definitely not. Definitely not. You have to pay. Why? Because if you don't pay, you are just delaying the problem. You're not solving the problem. So instead of paying, let's say your lease amount per month is 100 KD. You didn't pay this month, and you didn't pay the next month, and the next month until the situation is resolved. After this period is over, and the landlord raises a case against you requesting for overdue payments, the court will most probably issue a judgment to the benefit of the landlord. So in this event, instead of paying 1 month by itself, you will have to pay all the months that you didn't pay at one time. And if you don't have any funds at that time, any cash, they can execute on your assets, and they can execute on part of your salary. So what's the best way forward? The best way forward in this situation is the following. Contact your landlord. Agree with your landlord to reduce the lease amount during this period to whichever amount you can pay and the landlord accepts in writing. In writing, you might not have a document. Agree in WhatsApp, agree by email, whichever manner of writing right now, because again, we are in situations which we have to think out of the box and go with the flow of the current era we are living in, but at least get something in writing. Agree to reduce the amount of the lease during this period. And to be frank, this solution is both beneficial to the landlord and beneficial as well to the tenant. The landlord right now, if they evict you, it will be very hard for them in the future to get somebody to replace you or to get somebody to rent that premises. Because right now we are in a market in which people are not requesting for leases, they're evicting their premises, they're traveling outside of the country. Lots of people are leaving already the country, going back to their home countries. So this would be a win-win situation for both parties. And this is the best way forward, in which you know that you don't have any surprises in the future. This is our advice in this regard. One of the things that has been already amended in the law during this period in Kuwait is Article 17 of Law number 38 of 1980 regarding the Civil and Commercial Pleadings Law, which was amended by Law number 5 of 220 issued on 29 April 2020, regarding the timelines of raising cases, regarding the timelines of raising any cassation or appeal cases, etc. So the amendment that happened is the one which I have underlined, which is the second paragraph, which says in the events where the Council of Ministers decides to cease work or give vacation to public official utilities as protection to the security, general peace, or public health that the higher interest of the country deems necessary, the period of vacation or suspension shall not be calculated among the procedural timelines, shall not be calculated among the procedural timelines as listed in this law and the criminal procedure law and the cassation challenge procedural law. And such timeline shall be in effect as of the date determined by the Council of Ministers to be back to work. So what does this mean? And this law, this recent law, is with retroactive effect, starting as of 12 March 2020. What does this mean? Let's say you already have a case in court, which already started before this situation, and a judgment was issued, first instance judgment, and you want to appeal that judgment. For you to appeal that judgment, generally speaking, usually it is 13 days to appeal the judgment from the date that judgment is issued. However, we are on lockdown. Courts are closed. There is a suspension of everything. So what this article means is that during this period, everything will be suspended, including timelines and legal timelines, until the Council of Ministers issues a decision in which they say, we have resumed work as of this day, and then the timeline will restart again from the date as determined by the Council of Ministers. And this is actually one of the great amendments to the law, which will protect a lot of rights going forward, which is the amendment of the timelines to raise cases and protection to everybody in the society. What should we expect next? We definitely should expect intervention from the government, as I said, to issue some kind of laws and regulations to govern the current situation from all perspectives. And I'm not talking only labor law and lease and all this. I mean, there are also loans, there are bank issues, companies are suffering, bank guarantees. So there are lots of other issues which we have not discussed today, which are going on as well. And I'm sure that there will be some kind of guidance from the government going forward in this regard to issue some laws and regulations to make sure that the damage is somehow contained. Because right now, everybody is suffering. It's not only small companies, big companies as well are suffering. Employees are suffering, executives are suffering. So this situation is on everybody, literally everybody. Those are some of the laws and regulations as well that have been issued during this period to make things easier. One of them is company related, and actually it's a very, very important resolution, which is Ministerial Resolution 85 of 2020, amending Article 118 of the implementing regulations of Law Number 1 of 2016, which allows virtual General Assembly meetings. So lots of companies were not able to do their ordinary General Assembly meetings during March. So this law or this resolution has been issued, allowing them to perform their meetings virtually. Through KCC, which is Kuwait Clearing Company. And this again is a very, very good amendment, and which has made it much easier on the companies to do their ordinary General Assembly meetings. Also, there's an administrative decision that has been issued organizing the businesses that are allowed to open during curfew and the working hours. This resolution is definitely in constant change according to the situation and day by day. Law Number 5 of 2020, which we have already addressed. And there is Circular Number 4229 of 2020, issued by the Council of Ministers General Secretariat to the Minister of Finance. This is a circular regarding government contracts and tenders and what needs to happen with government contracts and tenders during this situation. So those are some of the relevant laws and regulations and orders that have been issued during this period. Of course, we expect much more to be issued in the next week or 2 weeks or whatever period we are looking at. Again, as I said, this presentation is a general presentation. It provides general guidance. However, you should not take it, of course, as a legal opinion to your situation. Each situation should be reviewed on case-by-case basis. because each contract is different from another, and sometimes there are provisions in some contracts which will change the whole situation. Those are my contact details if anybody would like to contact me later for any further questions. And right now I'm gonna start looking at the questions and answering them one by one, or as much as I can, because there's a lot of questions out there. So Yasmin is asking, does a public situation discriminate between public and private sector? No, it doesn't. What we mean by public situation, we mean by a public situation a situation that affects everybody. So the situation we are in and the COVID-19 and the shutdown, it is affecting public sectors and private sectors. So it's affecting everybody. This is what we mean by a public situation. George is asking, sorry, he's saying this is privately. Okay, I'll answer that later then. One of the participants is saying that the rest day is 125%. The 125% is a normal day, not a rest day. A rest day is 50%, according to article, let me give you exactly which article. %125% is for overtime during a normal day. 50%, which is article 66. The 150% is for a rest day, for example, a Friday. So if you work on a Friday, you get paid 1.5 salary plus 1 day off. But again, this is the law as of today. And to be frank, I don't think this will be possible to implement under the current situation. Otto is asking, no salary reduction understood during the current crisis. What about benefits as housing, airline tickets, accruals, etc.? Right now, you could say that everything is suspended. I mean, okay, you need to get paid. The housing and the airline tickets and the accruals, those are usually okay, let me divide this one by one. According to Kuwait law, a salary is not only the basic salary. A salary is any payment that you get on regular basis. So if every month you get your basic salary, you get your housing allowance, you get your transport allowance, every year you get your ticket, and it is written in your employment agreement that every year you need to get a ticket to your home country, then this will become regular payment. Any regular payment in the contract will be regarded by law as salary. So yes, those are part of your salary. And if your salary is paid, those have to be paid among or along with your salary, if they are regularly paid. And I insist on the word regularly paid. Somebody's asking, what if the salary reduction is mutually agreeable? You can right now agree to whatever you want, to be frank, with the current situations. As I mentioned in the beginning, العقد شريعة المتعاقدين, meaning that the parties to the contract are free to agree to whichever provisions they want, as long as those provisions do not contradict with public policy, with ethics, and with orderly provisions of the law. One of the orderly provisions of the law is the article in the labor law which says that the employer is not allowed to reduce the salary. So even if the employer comes and agrees with you to reduce the salary, you can agree, of course you can agree. However, legally speaking, this contradicts with one of the orderly provisions of the labor law, and therefore, in principle, it will not be valid. However, during this situation, as I said, which are unprecedented, lots of companies are reducing the salaries, and they are aware of this provision in the labor law, but they have no other option. Unfortunately, they have no other option, because the other option will be termination of agreements. This is the only other option for an employer at this stage. So either terminate or reduce the salaries, knowing that is illegal. Somebody else is asking whether Lilwa is asking, currently any agreement to reduce will be null and void. Yes. Any agreement to reduce the salary will be regarded as null and void because it contradicts and violates an orderly provision of the law. That's why, that's the reason. Unless the law is amended. Unless the law is amended to say, as what happened in Dubai, the law is amended to say that the employer and the employee are free to agree to reduce the salary. Then in this case, yes, it will be valid and it will be enforceable. Somebody is asking, our company is telling us they want to open a new bank account for us all without our authority. Can they force this? No, they can't. Opening a bank account is a personal thing. So you cannot, nobody can open a bank account on with your own name without your approval to opening that bank account. They need your civil ID or your passport, and they need you to sign some documents for opening that account. So opening any new account, it has to be according to your approval. They cannot do that by themselves. Nobody can open a bank account on your behalf. Rochelle is asking a question, but it is more of a personal question. So Rochelle, I would ask you please to contact me after the presentation is over. You can contact me by email or WhatsApp or phone, because it's a specific question. Sharif is asking, if the rent is not paid, can the landlord evict the tenant if the renter is out of Kuwait and can't come back now? That's yes. So I've answered the first portion of the question, which is basically if you don't pay rent, can the landlord evict you? Right now, they can't evict you simply because the courts are closed and they don't have any legal procedure to follow to evict you right now if you don't pay. If you are out of the country as well, they cannot evict you. I mean, what will they do? They will come in and throw your furniture out of the house. This will be an issue as well, because if they come into your house and you are not in the house and they throw your furniture, this will be a criminal offense. So somebody entering your house, even though it's the owner, somebody entering your house without your approval and basically putting their hands on your furniture, during those times, nobody can do it. This is definitely not something that can be legally done. Somebody's asking, can the employer reduce the working hours and the salaries accordingly to circumvent the prohibition on reducing the salary? Well, the law has differentiated between several types of contracts, the labor law. There are contracts where employees are paid on monthly basis, which is, I would say, 9% of the population are on such contracts. And there are other contracts in which the employee is paid per piece or per hour or per week or something like that. So those are two different types of contracts. If the contract is a monthly paid contract, they cannot transfer that employment contract to another type. So if it's a monthly contract, they cannot transfer it to an hourly contract during the continuity of that contract. They can terminate that contract and establish another one, yes, but also it is not that simple. So Again, because we go back to the article which says that you cannot reduce the salary. If we want to talk pure legal, if you want to terminate the employment agreement of somebody and rehire them, you need to terminate with a lower salary. You need to terminate the employer contract, take those employees out of your iqama, and then rehire them, which is a headache, and nobody's going to do it. So if we're going to talk pure legal, it's going to be a long process, and actually it's undoable right now. Again, because most of the authorities are closed, and it is not easy right now to get access to anything or to change any procedures with anybody. Casper is asking, what about the loan repayments, such as vehicle financing? The Central Bank of Kuwait, as well as the government, are already looking into this, and there has been some certain laws and regulations which have been issued as well from that perspective, in which they said that during a period of time, the payment of loans will be suspended. However, you need to contact your bank and check with them. And what I would advise you is also keep an eye on the Central Bank of Kuwait website to check whether there are any laws and regulations. When this regulation was first issued regarding the loans, it was issued only for Kuwaitis, and then it was for everybody, even for expats. So right now, the banks have suspended payment of loans, as far as I understand. I might be mistaken. I don't know if there's any changes, because the changes are happening very fast right now. We're trying basically to follow all those changes and amendments. However, what I can do is, Casper is asking, if you can contact me, Casper, later on, I can check for you. I can check the laws and regulations that apply, and I can get back to you with an accurate answer. But as far as I'm aware, you shouldn't pay any loan payments right now. However, you need to contact your bank to get affirmation on that. Somebody is asking, does the emergency situation not invalidate the labor law? As I said, during the Iraqi invasion, we didn't have Article 61. And further, we didn't have internet. And further, we didn't have virtual communication. So at the time of the Iraqi invasion, the labor law related matters and an employment agreement were regarded as emergency situation and suspended. I think I answered this question, but I'll repeat it. And during the implementation of that agreement was suspended during the period of the war. So the employer was not paying, the employee was not working. However, the employment agreement was still valid. Nowadays, the situation is different. Nowadays, the situation is different because the law was amended in 2010, and the provisions are different from what existed during the Iraqi invasion. Right now, yes, we are in an emergency situation. Whether the government will regard labor laws as emergency situation as they did during the Iraqi invasion is something which needs a legislation. However, as of today and as of what the labor law stipulates, the employer has to pay according to Article 61. They don't have any other option, because Article 61 is very clear, or else they have also the right to terminate the employment agreement. So it's different situations. Roshan is asking, in case of commercial lease, let us say we refuse to pay the rent due to facilities not being used. What happens to the assets and the IT infrastructure? What happens, I mean, right now the situation will remain as it is, suspended. As I said, the contract is still in place. You didn't terminate the contract. So the premises will stay as it is. The furniture and the assets will stay as they are. It is a suspension period. It is not termination. In the event of termination, let's say you agreed that, yes, let's terminate the agreement. If you terminate the agreement, then you have to move your assets and your furniture and your IT and everything. You have to move them out of the premises if you terminate. However, if the landlord does not send you a termination letter or does not send you a notification to evict, then in this case, this means that the contract is still valid and still in force. And therefore, you leave everything as it is, suspended, until everything is resumed and is back to normal. Yasmin, I'm still confused with regards to a commercial lease. Private medical establishments have been closed by the government. Should a clinic's rent still be due for the period closed, assuming no provisions in rent contract? Okay, let me be specific about this. The principle is that you have to pay, whether commercial or residential. The principle, you have to pay your lease amount, your lease payment. This is the principle. If you can pay or you agree with the landlord or the owner to reduce the lease amount during this period, that is also great, whether for also both commercial and residential. The difference, however, in the commercial lease is that there are precedents on that, and those precedents in the past have said that during the suspension period, the commercial or the companies are free, not free, are basically, if they didn't pay the rent, it was okay because it is a suspension, but the agreement is still valid, so it was not terminated. So basically, if you are a medical establishment and you are not working and you are not using the premises, you can basically contact your owner and tell them that during this period, but you need to make sure that it is a commercial agreement. Again, the commercial investment agreement is the same as a normal lease agreement with extraordinary provisions, such as, for example, ta'min, which is the which is the insurance or anything to the like. Our office premises is a commercial investment. We informed them we are leaving. They want us to find a replacement or to pay 6 months plus losing the insurance we paid. I'm not sure what kind of insurance. Do you mean by insurance that you paid is the like down payment or something like that? I'm not sure what do you mean by insurance. And you're saying that they are requiring you to pay 6 months based on what? So that's one of the things that I'm talking about. I need to see the contract. So there are some specific provisions in that agreement which we have to take into consideration in order for me to be able to answer that question. But I'm assuming right now that what you mean is that according to the contract, if you terminate the contract, the lease agreement before its time, you have to pay at least a 6 months payment, I guess. I'm not sure about that. You need, again, please contact me after the presentation privately. I need to see the contract for me to be able to advise properly on that question. But sometimes there are provisions in the agreement that will change the general advice, which is in this case. Talal, what about the effect of Article 198 of the civil law that you have raised at the beginning of the presentation on employment contract? There is a clear unbalance in the parties' rights where the employer pays the full salary and the employee is not delivering the full service. What if the situation goes on for months? What could be the solution? As I answered a bit ago, regarding the emergency situation and whether it applies to labor law or not, it applies to labor law. Yes, according to precedents and according to what happened before, yes, in general. However, and there is definitely, as you are saying, imbalance in the obligations of both parties because the employee is not giving 100%. they're working as much as they can virtually. They're not giving 100%, so they're not delivering their part of the obligations as they should. However, we have Article 61, and Article 61 is the big difference, which makes a huge difference to the theory of the emergency situation and forces the employer to pay salary during shutdown. The only way to make that balance happen again is for the government to make an intervention and issue laws and regulations to govern the relationships right now. As I said, Dubai has done that already. I expect Kuwait to do the same, simply because both parties are being damaged. The employer is being damaged and the employee is being damaged. As I mentioned, a lot of employees do not want their contracts to be terminated. They prefer reduction of salary than to be terminated. So we are expecting an intervention from the legislator. My company is a party to a fixed price government contract, lump sum. So somebody is asking, my company is a party to a fixed price, I guess lump sum government contract, which has been concluded, but yet to start implementation. So it didn't even start. We gave the client an irrevocable bank performance guarantee at the time of contract signing. Yes. The execution of services under current circumstances has become cost prohibitive for the company due to inability to source foreign labor and price gouging by local material suppliers. Does this type of situation classify as impossible to perform or tough to perform? That's a very good question. There was a similar precedent regarding this exact situation during the Gulf War, or after the Gulf War was over, and it was also regarding a government contract. However, the court precedent which I'm talking about was regarding a bank guarantee related to a government contract at the time, which is similar. At that time, the contract regarded the situation as an emergency situation and not as a force majeure situation. So they regarded it as burdensome and tough to perform, not impossible to perform. And from what you have, the information, the small information that you have given so far, it would be regarded as an emergency situation. So the contract right now will be suspended until the time the government says that everybody can go back to work and go back to normal, which we don't know when is that. And then at that time, we will need to perform according to the contract specifics. Generally speaking, if I take a look at that government contract, there might be, of course, further advice that I might offer according to what is written in the contract and to specifics of that contract. But generally speaking, a very, very similar situation was available during the Iraqi invasion, and they applied on it the theory of emergency situation, not force majeure. Let me give you an example of the difference between emergency situation and force majeure. Let's say you ordered a car, okay? Before all the situation happened, you ordered a car. And, or let me say the situation was a war, not COVID-19, it was a war. And at that time, you have ordered a car from somewhere with specific characters in that car. And then the factory where the car is manufactured gets bombed and the car disappears. In this case, the factory cannot perform their obligation anymore because it is impossible for them to perform it because the car does not exist anymore. However, if nothing happened to the factory, but they are unable to deliver because of the current situation, then this will be regarded as an emergency situation in which the obligations are suspended, and then after the obligations are suspended, they will continue performance of the obligations and they will deliver the car for you. So instead of delivering the car for you right now, they deliver it. Let's say that you have agreed with them that they will deliver the car today. They will delay the delivery until 3 months or 4 months, whatever the period is. However, they will deliver. So it will become more burdensome to deliver, but not impossible. So this is just a very slight example, just to give you an idea what's the difference between force majeure or impossible to perform and burdensome to perform. This is the major difference between them. Hassan, can we have a copy of the presentation? Yes, you can contact me after that and we can discuss what's the best way forward, of course. Somebody's asking, as per the law, local or international, could the Kuwaiti government be liable for compensating private sector companies for their losses during this period, particularly given that the government's current laws do not provide the companies any relief on labor law or lease expenses? Could companies resort to international law in the event the government does not offer such compensation? Well, to be frank, right now, I don't think whether you resort to local laws or to international laws will make a difference. Everybody's suffering, whether Kuwait or other than Kuwait. However, in principle, the Kuwait government is definitely not legally responsible or is obliged legally to compensate any of the private sector companies or parties or anything to that extent. What they can do and what they are doing is that they are working with everybody. They are working with lawyers, they are working with legislators, they are working with stakeholders to basically try to reduce the damage as much as possible on everybody. What they can do is issue laws and regulations to try to keep things as much as possible working, I would say. And let me use the word survival mode. They need to try as much right now to keep things in the survival mode. But do they have an obligation to compensate? No. Lilwa, do you think that the Kuwait Labor Law amendments will mirror UAE regulations? UAE amendments state that they will apply to non-nationals and private sector, yet to issue regulations pertaining to UAE nationals. Right. When I refer to the UAE law, I was not referring to the UAE law to basically say that Kuwait has to follow UAE. I am saying that to say that Kuwait has to issue laws and regulations for the best interest of Kuwait. So any amendments to the laws and regulations that have to be amended in Kuwait should take into consideration that those laws and regulations should be tailored for Kuwait needs and should be tailored according to the interest of all the stakeholders in Kuwait and to the current laws and regulations. When I refer to UAE laws, I refer to them basically because UAE, let me say, is the most, the nearest country to Kuwait, even from the legislative perspective. I mean, a lot of laws and regulations in the UAE are similar to those in Kuwait. Even the labor law, if you look at the labor law of Kuwait and the labor law of the UAE, they are very, very similar in many perspectives. So when the laws are issued in Kuwait or any amendments to the laws and regulations, those laws and regulations should be tailored to Kuwait needs in a manner to balance and be fair to all the stakeholders in the country. Somebody is asking whether they can get a copy of circular 4229. Yes, absolutely. Just contact me after this and I'll be happy to send it through. Absolutely. This is public information. Maria is asking, can we force the employees to take their vacation during this period and not when they want? Well, as I said, the government has announced that the first period, the first 2 weeks were official vacation. So in an official vacation, it's an official vacation, it's paid for according to the law. So it's not annual vacation. The second portion, the second 2 weeks, which will end on 29 April, were regarded by the government as rest days. Again, rest days are paid for by law. So the question whether you can force them to take their vacation during this period, legally speaking, no. Practically, a lot of companies are doing it. Legally, you shouldn't, because the government has already classified this time as official vacation and rest days. So when you come and force them to take it from their annual leave, you are basically violating the the regulations which were issued by the government to that extent. But yet again, as I said, practically it is happening. And to be frank, I cannot, I can see why companies are doing it. Also, the companies are in a very, very tough position right now. They're trying as much as possible to stay standing on their feet. It's not easy. So right now, everybody is trying to do whatever they can do. Legal side is something. So right now we are discussing legally what is going on for everybody to be aware. But practically, a lot of people are doing things in hope that certain laws and regulations will come out to regulate it. Badia, but they want to replay. We inform. Our office is in an investment contract. We informed them we were leaving, but they want a replacement, which is impossible for us to find in this situation. So they want us to pay 6 months invest. I think I answered this, the exact same question before. Hi, Ola. To renew. What is the status to renew iqamas and visas now? What happens if they expire during this period? Well, that's a big question. Everybody also is asking it. Let me start by saying that if it is a renewal of iqama and visa, you can do it online. This can be done online. I can definitely send you the website. Your employer should be able to do it. Your employer should have a registration with the Ministry of Interior in this regard, and should be able to renew your iqama or your visa online without the need to go anywhere. Except, of course, an extraordinary situation. For example, there's somebody, they need fingerprint for them to be able to renew their iqamas. Of course, right now they cannot do the fingerprint. So that right now they're unable to renew the iqama because it needs a physical interference, which right now cannot be done. However, if it is a simple renewal, it can be done online. Just contact your company and they can simply do it online. April asking, can employees sue a company for reducing the salary from 10% up to 25% according to salary level during the shutdown, using an email to inform the employees that the company will do so? Is it smart to inform this reduction in writing or rather verbal? We have a total shutdown as we have retail shops in the malls. Well, as I said, legally speaking, they can't. As of today, legally speaking, they cannot reduce the salaries. Okay? Can you sue? Yes. Right now, can you sue? No, because everybody is closed. And in labor law matters in particular, you cannot immediately go to court. You need first to go and file a complaint in front of the Ministry of Social Affairs and Labor. So you cannot do anything right now before that complaint is filed, and the ministry, as everybody is aware, is closed right now. And a precondition for your case to be valid is that you file the complaint. So right now you can't. After the situation is over and you check your position, and if there were no laws and regulations issued and the law is still as it is as of today, you definitely have the right to sue. Somebody's asking me what is the best time for me to receive a call. listen, the best thing, if you want to contact me, you can either send an email and then we can, with a short summary of your particular situation, and we can take it from there. And by phone, just send a WhatsApp as well, and I will definitely get back to you as soon as I can. So if I don't respond immediately, I will trust that I will respond. However, it might take hours or maybe a day to respond to your particular question.
Okay, Ola, I think that's
Yes.
all the time we have for now. So thank you so much for that presentation. It was very, very informative. And as you guys can see, you can contact her directly if you have more personal questions. And again, we would like to thank all of you for being part of this webinar. And please, if you would like to become a member of our Chamber of Commerce, don't forget to go to our website at www.abckw.org or contact me directly at membership@abckw.org. Thank you so much.
Thank you, Paula, and big thanks to ABCK for organizing this. And please, everybody, stay safe during those times. And as I said, if anybody has any questions, please contact me directly. Thank you, ABCK, again.
Thank you so much, Ola.
Bye.